I think we want to get started. I want to welcome everyone to the U.S. and Human Rights at Home panel. And I want to welcome our speakers. I'm going to introduce them, and they have the fuller bios and the background materials you have. But first, to my left is, my immediate left, Gera LaMarche, who is the president and CEO of Atlantic Philanthropies. He was previously the director of U.S. programs at the Open Society Institute and also the associate director at Human Rights Watch. John McGinnis, who is to my far left, and this is perhaps the first time John has been to my far left, is a professor at Northwestern Law School. He's held several government positions. Currently, he is the chair of the Government's Advisory Committee on Free Trade Agreements and Labor Standards. John and I were on a ACS National Convention panel a few years back that I believe, Gera, I think you were perhaps moderating, and Harold Coe and Pat Wald were on as well. And I just recall it was during the John Roberts confirmation hearings when story broke that he was, that John Roberts was a member of the Federalist Society, and the White House quickly said, well, no, he's not a member. He just attended a couple of events. And John said that as a proud card-carrying member of the Federalist Society, he felt more welcomed here at ACS than he did at the White House at that moment. So that was quite a moment, and we welcome you back, John, to ACS. Then we have Cindy Suhu, two over from me, who is the director of the Domestic Legal Program at the Center for Reproductive Rights, and previously directed the Bringing Human Rights Home project at Columbia Law School. And then we are very fortunate to be joined by Wendy Patton, who is a senior policy analyst at the Open Society Institute, previously worked at Human Rights Watch, and also was involved in President Clinton's interagency working group on human rights treaty implementation, a topic which we will be addressing today. I'm Catherine Powell, and I'm a professor at Fordham Law School, where I teach international law and human rights. And I co-chair a new ACS working group on international law and the Constitution, along with Cindy Suhu, Jamil Dakwar, who's the head of the Human Rights Program at the ACLU, and Laura Dickinson, who teaches at Connecticut Law School. And so we welcome you to sign up for that working group if you're interested. There's a sign-up sheet out front in the reception area and also on the website of ACS. You can link to it from the front page. I'm just going to give some introductory remarks to sort of set the stage on why we even have a panel on human rights at a conference on constitutional rights and the U.S. Constitution. And in some ways, I think we might want to echo some of the themes from the plenary we just came from on reconstituting our constitutional framework to address a fuller meaning of human dignity, which is very much at the core of the idea of human rights. Of course, over the last 8 years, the U.S. has not been terribly engaged in international organizations, international treaties, or has not engaged with the world in a multilateral way. Yet, if we look back at the founding generation, we see that treaties are the supreme law of the land in the Supremacy Clause, and that the U.S. Supreme Court in its early days was very comfortable regularly consulting international law and comparative law in working through regular, everyday doctrinal puzzles. Plus, this year marks the 60th anniversary of the Universal Declaration of Human Rights, the UDHR, which the U.S. played a leadership role in founding and establishing. Franklin D. Roosevelt's annual address to Congress, one of his annual addresses now known as the For Freedom speech, very much paved the way for the UDHR when he, in the aftermath of the Nazi atrocities, called for freedom of speech, freedom of religion, freedom from fear, and freedom from want. And Eleanor Roosevelt played a key role in the drafting committee of the UDHR. So Roosevelt is written all over the UDHR and all over human rights. But at the same time, today, while there has been a bipartisan commitment over many generations of the U.S. promoting human rights abroad, the U.S. government has not always been so active in promoting the idea of international standards concerning human rights at home. So to give you a larger picture of the kinds of issues that we'll be dealing with, or that at least this panel is situated in, the U.S. has ratified a number of important human rights treaties addressing genocide, torture, civil and political rights, and race discrimination. But at the same time, the U.S. has not ratified other key human rights treaties involving the rights of women, the rights of children, and economic rights, including basic rights like the right to health care and education, which people are addressing in other parts of this convention. Our panel today will primarily address the Convention on the Elimination of All Forms of Race Discrimination, otherwise known as CERD, but we'll be using this as a way of addressing some of these broader issues concerning human rights. The U.S. Ratified CERD in 1994. It was adopted by the General Assembly 20 years previous to that in 1965. And just this past year, earlier this year, the U.S. reported on its compliance before the UN committee that oversees CERD, aptly known as the CERD Committee, in Geneva, where the CERD Committee held hearings. And we had the ACS Working Group on International Law and the Constitution recently had a briefing on Capitol Hill for staff members of Congress to talk about what the U.S. can do in following up from this recent compliance hearing before the CERD Committee. So today we are very excited to be able to reach out to a broader audience beyond the Hill to talk about these important issues. So I'm going to start by asking the panelists a series of questions, and we want to make sure to leave plenty of time for discussion to engage with you. And I first just wanted to ask our panelists, what is the value of human rights treaties like CERD, particularly because when the U.S. ratifies them, they oftentimes attach many conditions that limit the enforceability of these treaties. Cindy, maybe we can start with you.
Okay. First of all, I just want to thank Catherine Powell, and I want to thank Judy Applebaum and ACS for organizing this panel. I think it's really a great opportunity for us to be talking about human rights in the United States. Before I answer the direct question about why treaties are, what the value of ratifying treaties are, I wanted to sort of frame the conversation a little bit, because I think when we talk about human rights treaties and the United States and human rights, there's actually two separate conversations going on, and I just want to highlight that for folks. And I think the first conversation is really a conversation between the United States and the international community. And I think that human rights treaties and U.S. ratification of human rights treaties is important in that conversation because it's really about continuation of U.S. moral leadership. It's about our ability to show respect for international law. And Gara and others, I think, are going to talk about that a little bit more. And I think that's normally actually the conversation we hear when we hear about the United States and human rights. But I think the second conversation is really a conversation between the U.S. government and its people. And I think that and when we ask why it's important that the U.S., why it would be important for the U.S. to ratify human rights treaties in this context, I think the answer is actually the same in the United States as it is in any other country. You know, ratifying human rights treaties is really about the government saying it has a fundamental commitment to protecting the fundamental rights of its people. It's an international legal obligation, and it's a moral commitment. And the significance, I think, of the human rights movement and the way that human rights has been used in other countries is that human rights treaties and human rights standards actually create a measuring stick against which to judge a country's laws and policies. And it enables an opportunity for activists in the country to think about our own laws and think about whether we're really living up to these fundamental human rights. And by making use of international human rights mechanisms and human rights advocacy, it creates an opportunity to expose this gap and allow activists in the country to think about how we mobilize and work for change. And I think that that's very relevant to this conversation we've also been having about how social movements relate to our understandings of the Constitution. And I think the human rights dialogue is about our understanding of fundamental rights and normative values in the United States. And just on the second conversation, I just want to add the point that this is actually a conversation that's really relevant in the United States and a conversation that the American people really care about. And I think that maybe this wasn't the case 10 or 15 years ago, but there was actually a recent survey by the Opportunity Agenda that shows that 8 in 10 Americans agree that we should strive to uphold human rights in the United States because there are people being denied human rights in our country. And I think, 10 or 15 years ago, I don't think that would have been the case. And I think that that the human rights conversation is really a conversation that progressive lawyers care about. I think, again, if we were to go back 10 or 15 years ago, I think progressive lawyers would have said, well, human rights is nice, but it's really about other countries because we have a robust legal system in the United States. We have one of the best legal systems in the world, and why do we need human rights? And I think that what's been happening in the last few years is we're seeing that the rights that we thought were protected under U.S. law are shrinking, and we're seeing our access to the courts being closed off. And people are thinking about, well, how do we start this dialogue again? And I think people are thinking about using it in human rights terms. And the other thing that I want to mention, which is actually is not as relevant for CERD, but the thing about human rights is that it allows us to open up another conversation. And we were starting to talk about this again in the panel that we just came out of. And that's that I think we're having a conversation here about how the courts have become more conservative and we've sort of lost rights that we had or access to the courts that we had, but also that there are rights that we've never actually recognized under our Constitution, but that actually reverberate with the American people. And these are the fundamental economic and social rights. And by entering into this human rights conversation, we can start to talk about that in the U.S. context.
Okay, thank you. I think Dara wants to jump in.
Well, I want to reinforce much of that and put a slightly different gloss on some of it. I think, in fact, I was going to talk more about the kind of relationship between the government and its people rather than the government and the rest of the world, because I think what I've seen, as a funder and a human rights activist in the last 10 years or so, 5 or 10 years in the United States, is an enormous on the one hand, kind of hunger for a linkage to a broader global movement. So what human rights offers is a language, a narrative, a set of values, that unites people across countries and across issues. And I think that particularly since progressives in the United States have, as we've been hearing, been battered in the courts, it's offered a kind of a unifying language and a kind of a hope. So what I noticed about 5 or 10 years ago was that grassroots activists were taking advantage of the language and the tools and international treaties and also international bodies. So that when I was at Human Rights Watch in 1990, I don't know what the year was, 2 or 3, we, whenever the U.S. Had to submit its first report on the ratification, on its compliance with the International Covenant on Civil and Political Rights, we did a joint report with the American Civil Liberties Union on the U.S. compliance, and we had a number of sections of that. And we went to the UN when the hearings were taking place, and I was struck that in the gallery, this was the first time I actually noticed that there was a kind of a grassroots movement developed. I found, like, all these kind of gritty grassroots groups, prisoners' rights groups, welfare rights groups, who were looking at this as a way to raise their claims and also link up to people around the world who are fighting the same struggle. So I guess the first thing I would say is that the bifurcation, even the name of the panel, kind of accepts a certain kind of bifurcation of human rights on the one hand and civil rights and civil liberties on the other. And there are a lot of reasons that we don't have time to go into in great detail here why in the Cold War and so on, the language diverged and why. But if you go around the rest of the world, and Atlantic's a global foundation, so the other places in which we work, South Africa, Ireland, you don't have that kind of bifurcation. We won't say, well, human rights are foreign policy and something else is domestic policy. The language of human rights is what's used domestically, and indeed the bifurcation of movements, whereas you have kind of what we call social welfare or social justice advocates over here, and traditional civil and political people over here. A place like Ireland doesn't exist. The children's advocates see themselves as operating in a human rights framework and using human rights language. So what we're doing, in a way, is coming around to where we were in the New Deal period with the Roosevelts, to I think, a kind of a uniting of these two spheres that really shouldn't have been separate over the years. So I guess what I see on the ground and what we've been seeing in funding the U.S. Human Rights Fund here, for instance, which funds a lot of grassroots activity like the Border Network and so on, I see on the one hand, on the ground level, there's a lot of passion and interest about human rights, and people really using the language and being much more sophisticated about at least identifying themselves with the standards, even though we are a ways off from having a government that respects them as much as they should. And then the more elite organizations, the American Civil Liberties Unions of the world, the kind of international human rights groups like Human Rights Watch, and the kind of domestic civil liberties organizations like the civil rights groups and the ACLU, all of them have made substantial strides in recent years toward talking about human rights and locating their work in an international context, and that's a hugely significant development as well. When I was on the ACLU staff and board years ago, actually a lot of the critique of international standards came more from what you might call the left or progressive standard, civil libertarians who felt that, the Constitution was pretty good, and international standards watered down, freedom freedom of speech or whatever. You don't hear that much anymore. And I guess the final thing I want to say is that, what you cited in terms of 8 or 10 people see human rights as important. I think that in that sense, our marketing job has been done very well by the Bush administration. So, when I was at Human Rights Watch, when starting a domestic program there, whatever year it was, 1991 or something. It was a hard sell in a lot of ways, because there was in the organization, a lot of people thought that it was a kind of a luxury to deal with kind of human rights issues in the United States. First, because you had a whole range of domestic advocates, and they worried that the things we were dealing with in many other places were so extreme, and the U.S. Didn't have. I mean, believe me, I don't think this was right even then, with the death penalty and the criminal justice system and a million different things you could talk about in the United States. But no one disputes that now. That's the sad fact of what we've been through in the last 8 years or so. You don't have to make the argument to anybody that human rights, that the United States, is a human rights violator, unfortunately, to a very extreme degree. And that case is understood.
Well, Gara, you alluded to the history of why human rights and civil rights diverged in the Cold War context, and I think that history is important. And we can even go back further to the debates around the Treaty Clause in the Constitution were very much informed by Southern states insisting on there being a 2/3 majority, supermajority requirement for ratification of treaties because of their interest in the context of trade and navigation agreements extending out to the West, and their interest in the slave trade. So even at the founding, there were considerations around race and inequality that informed the way the U.S. approaches human rights. And then in the Cold War period, or even earlier than that, following World War II, when Southern segregationists were very concerned about the use of human rights in this sort of new post-World War II order being used to pass anti-lynching legislation in the Congress and other civil rights legislation. And so Senator Bricker tried to amend the Constitution to make it harder for treaties to be enforced. And fortunately, that was defeated, but we now, as Professor Lewis Hinken says, we live with the ghost of Senator Bricker because the U.S. in ratifying treaties still attaches these reservations and understandings and declarations to make treaties very hard to enforce. Today, though, Gara's talked about how grassroots groups in the civil rights and civil liberties, social justice context are beginning to embrace human rights, and during the civil rights era of the 60s, there were many civil rights leaders, the NAACP and W.B. Du Bois and other civil rights leaders who filed petitions with the UN, but that kind of tailed off in the 70s and 80s to U.S. constitutional litigation. But today we see a reemergence also in the context of the war on terror, and I know that's something, Wendy, that you've been very much involved in, and I wondered if you might be able to talk a bit about that dynamic between how human rights seems to come quite naturally in the context of detainee rights. We're talking about Guantanamo, torture and accountability, but that isn't entirely linked up with the rest of the social justice movements and the emerging sense of using human rights outside of the context of the war on terror.
Sure. I also want to thank Catherine and ACS for organizing this panel, and I am here as a last-minute substitute for Ajamu, and happy to be here and join in the conversation. I do think, and I think as Cindy will talk about a little bit more, and as people have said in their remarks thus far, a lot of the initial impetus in the 1990s for beginning to think in a new way about how to use international human rights language, standards, and mechanisms in domestic advocacy emerged from people who were concerned with issues of economic and social justice. But I think what we see happen in the aftermath of 9/11 in response to a range of counterterrorism policies is a little bit of a shift in focus toward civil and political rights. That doesn't mean that advocates on the ground who were continuing to work on a whole range of economic and social justice issues weren't continuing to do that, but that I think a set of core civil and political rights issues came to the fore in a new way and took on a new urgency, in large part, I think, because they fell prior to that in the category of rights that people considered largely one, that is, largely guaranteed by the Constitution and U.S. law. That isn't to say that there weren't instances in which that principle was honored in the breach, and there wasn't a great deal of advocacy to try to defend those rights, and instances when they were violated. But there wasn't a sense that the tools that advocates had long had, domestic litigation, legislative advocacy, and the rest, weren't sufficient to try to vindicate those rights when they were violated. But in the aftermath of 9/11, and there were a whole host of policies that led to a certain kind of erosion of those rights. So just to take one example, the arrest and detention of some 760-plus non-citizens on immigration charges as part of the investigation into the Pent Bomb investigation, the investigation into the 9/11 attacks, which sort of fanned out from New York, but many of the detentions were in the New York and New Jersey area. What you see with that is a range of groups using the language of human rights to talk about what was happening, using the standards to try to reinforce the principles involved, and also using some of the mechanisms or the strategies. And in particular there, I'm talking about one of the main strategies that a lot of the human rights groups have used, which is human rights documentation or fact-finding. You know, going out and carefully documenting the facts of what was happening to those who had been detained, and then being able to aggregate that to tell a story about what had happened. And then I think that was very powerful. It was done principally by Human Rights Watch, also by a couple of other groups, and followed on in various ways that I think helped to shine a spotlight on them that was captured finally by a report by the Inspector General at the Justice Department that was, some 200 pages long and had 22 specific recommendations of things that the department needed to do differently with respect to those who were detained. So that's just one example. In response to the part of your question, Kathy, that dealt with who was involved in this, I think one of the challenges of thinking about bringing human rights home, of talking about human rights in terms of the U.S.'s own conduct in the current moment, has been that some of the conduct occurs by the United States outside of its territory, and when it is outside of the territory, and we spent a long time wondering about exactly what Guantanamo was, but I think we have greater clarity on that thanks to the Supreme Court. But Guantanamo, in a way, certainly for how it's been up to now, people weren't quite sure whether what that was, or further abroad. For example, the horrific photos from Abu Ghraib. I think, in a way, that did play in a little bit to questions of, well, is that something that, the international human rights groups will speak to or is that something that we'll do here and try to frame as a civil rights issue for groups that are talking principally about things that are happening in their communities at home? And I think we've seen a slow convergence among groups in understanding that this is fundamentally about government power and the way it's exercised, whether that conduct happens outside U.S. territory or at home. And a good example of that I can give is that a lot of the commander-in-chief theories that have undergirded the notion that you could set aside laws prohibiting torture, we only later learned were then applied in the context of domestic surveillance to set aside the existing law to violate privacy rights at home. And I think that's helped us draw linkages between these different areas and to, in the way you've described, blend the work of traditional domestic advocates with the human rights groups that are working on U.S. conduct at home.
And Wendy, thank you for reminding me that Ajamu Baraka, who was originally supposed to be on this panel, couldn't make it because of a family emergency. Well, John, so given what we hear in terms of the value of human rights, what's the objection?
It's not an objection to, when I look at international rights, it's not an objection to human rights at all. The question is, how are we best able, and I'll look at it at first in the context of the United States itself, to vindicate and form good beneficial human rights. And the question is, what is the best process to do that, in my view? And the process within the United States is likely to be better than the international process, at least as it's structured currently, and certainly as it's structured, which gave rise to these kinds of treaties. Now, let me begin by saying that, of course, while I'm very enthusiastic about human rights, it may be that I have some differences between the kind of human rights I'm enthusiastic about with some members of this panel, but I think that actually is an important point, because that's, of course, been the case since the idea of human rights was essentially invented in the West in the 1800s. Locke has disagreed with Rousseau. Nozick has disagreed with Rawls. So the question is an epistemic one. How are we going to discover what the content of those human rights are? And it seems to me the best way, and I'll be happy to chat more about this in questions, the best way is essentially a democratic system, including, as does our system, a system of higher democracy where we have the requirements of supermajorities who will deliberate at great length and perhaps behind a greater veil of ignorance to create some human rights. But there's still essentially a democratic, participatory system that creates these rights. Even our judiciary is of course nominated by the democratically elected president, has to be confirmed now by the Senate, and is quite transparent to our people. That seems to me to be a pretty democratic system of elaborating on human rights. And I think it compares very favorably to the international system, at least as it currently exists. And so let me just give an example of the Rights of the Child Convention or the rights of economic and social development. What are the problems with looking to those as the way to elaborate human rights rather than our own system? I'd at least name three of them right off the top. One is, sort of embarrassingly, in the old human rights treaties, some of the totalitarian nations participated in structuring them and the give and take on what those rights are. Now, of course, that doesn't mean that any right in particular is bad, but I think it has to give us some pause before we're going to ratify these all together, because there was a give and take here, and of course these evil empires had some substantial influence. The second point, even if you separate out that, is the question of how seriously the talk is, how seriously we should take these human rights, given the way that not only the United States hasn't made them largely self-executing, hasn't made them part of domestic law, but that's true of other nations as well. They're not often part of their domestic law. Many nations are dualist, which is a technical term in international law, that they actually have to have a domestic decision to bring in rights over the transom. And that means that the rights are necessarily, it seems to me, more cheap talk. You're going to be more serious about what is the really good content of rights if you're going to be sure they're going to be enforced on the ground every day. And then finally, the point is that just the whole international human rights process seems to me much less transparent to the ordinary citizen than is our own democracy. And that seems also to me a very large cost, because that allows special interests and ideological interests, and I'm nothing against such people trying to make their voices heard, but I think it gives them particular power, because it means that the broad citizenry, which doesn't know a lot about domestic politics, its knowledge of international politics and international human rights process is really exiguous, and we actually have some pretty good empirical data on that. And so I'm not against human rights, but I think at least to me, what the international human rights community should take more seriously than it seems to me to do is the process problems in the creation of international human rights.
Oh, well, John, where you talk about the democracy deficit, and this is a criticism we often hear, mainly human rights come in through the vehicle of treaties, right, which are ratified by 2/3 of the Senate and the President. So there's a democratic process then for importing these treaties, like the Torture Convention, which President Bush said should be set aside in the secret torture memos, and other treaties that have not been taken seriously. So on the one hand, it seems that the democracy deficit argument is really a red herring because the political branches have acted. But on the other hand, don't we really need a richer conception of democracy? So, again, the plenary just talked about how we do have the idea of majoritarian democracy, of the political branches acting, but we also, have very much believed in the idea of a kind of constitutional, what Ronald Dworkin calls a constitutional conception of democracy, that we can't, that courts have to play a role, and in fact can be more representative of all the people who are underrepresented in the political process, so, minorities, women, et cetera. And I think, we just saw the court in the Guantanamo cases basically say that even where the Congress and the President have said that habeas can, we can do away with habeas rights for detainees, that courts still have a role to play that, to really represent the rights of all the people in a more thoroughgoing, representative way than if we just leave all the decisions to the political branches.
Let me just jump in and jump back here. Of course, I was discussing whether we actually should ratify more of these treaties rather than we should obey the treaties we have ratified. Certainly, treaties that have come through our process and that we make self-executing suggests the degree that we should follow them as the rest of law. And I certainly am not here to defend the torture memos, which I've otherwise said were not to be certainly were at least counterproductive. I certainly that's not my concern. My concern is, should we think this is a good process? Should we think that because which I thought was part of the agenda, should we be thinking of ratifying these treaties because they are international human rights norms? And I think there's some problems with these international rights norms, particularly those that are much more broadly based than something like trying to outlaw torture. You're absolutely right. We have a system, a complex system, and of course we could have a long discussion of what the nature of our political system is as it relates to constitutional law. But I would claim that even our constitutional law system is more democratic and transparent than the international legal system. I mean, everyone knows who John Roberts is, or most people know who John Roberts is. I don't think anyone, or almost anyone from the street, could name who the members of the ICJ, the International Court of Justice, are. They understand who their congressmen and how they pass statutes that, of course, relate to human rights. But the international human rights process is completely opaque to them. So I think even if we accept the idea that we don't have a simple democracy or simple majoritarian democracy, that doesn't mean that elements like transparency, and some democratic accountability are not still important parts of that system, and which seem to me, at least for many of the human rights treaties that have previously come into effect, seem not. I think that there was just not that kind of system operating. Maybe in the future we could imagine such a system in a world where most nations were democratic. We're still a little ways from that, and we're certainly, I think, a very long ways from that with many of the treaties which many international human rights would like the United States to ratify.
I think Dara would like to jump in.
I think that's a somewhat fair point about transparency and democratic participation. It seems to me to argue for, though, not against, the trend that we've been describing, which is to say that people in a democracy, all democracies, take an interest in, understand what's in the treaties, utilize the system. So it seems to me to be more of a call for participation, for greater participation than against it. But the small but not insignificant, I think, point that I wanted to just make in response to one of the points that was made is, this idea that somehow because totalitarian regimes were involved in ratifying treaties, evil empire states, if you will, that somehow delegitimizes them. I don't think so. I mean, I think if you look, for instance, at what gave rise to the birth of Human Rights Watch, which was Helsinki Watch, which was the Helsinki Accords that were negotiated in the early 70s by Ford and whoever was the Soviet premier at the time, I can't remember. Soviet Union thought that was kind of a free hit, as it were. They didn't take the Accords very seriously, but the dissidents did, and they formed the fact that you had standards that the Soviet sphere had pledged itself to uphold was a very, very powerful tool that led, some 15 years later, was one of the key things that led 15 years later to the collapse of the evil empire. So I think you have to look at the content of the standards themselves, and very often governments do things for all kinds of craven reasons that end up biting them in the ass.
I'm sure. There were so many things he said. So I agree with Gara. I think a lot of what we hear when we talk about human rights in the United States is, well, other countries have ratified these treaties and they're not really fully implementing them. But and it's cheap talk. And I think the fact that other countries are not fully implementing their treaty obligations doesn't mean that we don't have to or we shouldn't be trying to. So I think that's a little bit of a red herring. I think this idea of transparency, I think that's a good point, because I think Geneva is far away for people to get to, and that's one issue that we were trying to address during the CERD review, where there was actually an effort to bring U.S. activists there, and there are actually about 140 U.S. activists, and it wasn't just lawyers and it wasn't just Human Rights Watch, it was actually grassroots people. I think also when we talk about people not knowing the system, I mean, perhaps that's really about us making sure that people are educated about human rights treaties and the human rights process. I mean, one of the things that the CERD committee talked about was the need for public education about the treaty and public education and education of government officials. And then the last thing about the democratic deficit, I think that, John has said that he doesn't have a problem with the treaties that the United States has ratified, and that has gone through a democratic process. I think the other thing about those treaties is that, there was a process by which the United States looked at the treaties, where the Senate thought about the treaties, and in fact, for most of the treaties, there are these non-self-executing reservations and understandings, which mean that the treaties actually don't have the force of domestic law. So what's happened is the United States undertakes this international obligation to protect and ensure human rights, but the treaties don't have force of law in the United States. So there's actually there is and should be a process whereby the United States government and its people think about how are we going to live up to these obligations, and I think it's actually part of a democratic process, and it should be a dialogue between the U.S. U.S. government and its people about how we fulfill these obligations.
I just want to make a couple of points. Just to pick up on what Gara was saying on the point about sort of questioning whether some of the norms may or may not be legitimate because of who some of the governments were that were involved. I think if you look at criticism of whether the principles are truly universal or not, say over the past 10 years or so, it would be fair to say that criticism comes most heavily from governments with really poor human rights records. And I think for that reason it's something to consider. It's one thing to talk about the content of different rights with an eye toward trying to ask whether those rights, whether we're trying to engage in criticism in order to improve them, in order to make human rights more fully human. But when you see governments like, who with really, really poor human rights records, I'm thinking of, criticisms levied by the Chinese government and others over the past 10 years toward these international human rights, it seems more to be about trying to tear that regime down. But when you step back and look at what those principles are, I think what's far more striking is how consonant they are with so many of the basic principles that Americans think of when they think of basic rights and in our own system, and that there's far more commonality than there is difference in that respect. The second thing I wanted to say was, I think we could have a long conversation on the topic of the treaty body reviews and what happens when advocates go to Geneva to participate in those reviews, and agree with Gara's point about, it seems to argue for more participation. But I also want to say that I think that we should remember that treaty body review isn't the only way in which these treaties matter here at home. It's one part of it, but it's not the only forum for conversation between advocates in this country and their government about what those human rights mean. And indeed, I think a central part of that process is bringing that conversation home and having it enrich what advocates are already doing to talk about the U.S.'s obligations under these treaties. And just to give one example that I was thinking about on my way over here is the Refugee Convention and the Refugee Act of 1980. That is an international treaty that doesn't have a treaty body with regular reporting like this, but the United States signed the protocol to the convention, and because of that passed the Refugee Act of 1980, and we have for 28 years now had a robust domestic legal framework for considering claims of asylum and considering resettlement of refugees from abroad, all of which started because we undertook an international legal obligation. So I think that's a good example where it's really about us talking about how to make this part of our domestic law and make that human right to protection against persecution real. So treaty bodies are important, but the treaty body review is important, but it's not the sum total of the conversation that advocates and citizens have with their governments about what these principles mean.
Mm-hmm. Well, Gara, you alluded to the fact that the U.S. really plays a dual role, that the U.S. Very much has fought for human rights in its foreign policy, for instance, vis-a-vis the Soviet Union and the Eastern Bloc countries. and today, with the access of evil, as President Bush likes to call it. But can the U.S. sort of have its cake and eat it too? Can we talk about how Afghanistan should ratify the Women's Convention in the fall of the Taliban and not ratify the Women's Convention ourselves? John, let me pose this to you.
Yes,
I
I
say no.
think you can. It does not at all follow. I mean, first of all, I'm not at all. I'm sort of skeptical that if we ratify things, other nations are going to more enforce human rights norms. I think they're going to make decisions on their own for that. But I think actually it's quite sensible to think that it may make more sense to enforce international human rights norms in dictatorial regimes or regimes that don't have well-functioning democracies than in not only the United States but in European regimes which do have well-functioning democracies. Because, again, it goes back to the comparative advantages of where you're going to get better norms. If you have a well-functioning democracy, for the reasons I've suggested, I think you're going to have better norms being made domestically, better in the sense that both it's going to be more transparent. And also, I think one other problem, which I think we should discuss as well, is the difficulty that one size of international human rights norms isn't necessarily going to fit all their peculiarities of different nations, and we really want to take those into account if we have a well-functioning democratic system. If we don't, on the other hand, it seems to me to be quite sensible to say that, well, the international human rights norms, they've got a pretty bad process structure compared to domestic democracy, but compared to actual dictatorships, they've got a pretty good process. And so I think as a theoretical matter, there's no necessary reason to see any need for symmetry in enforcement of the United States norms. So I think it makes perfect sense for us to suggest that the norms should be enforced in Afghanistan, but not in the United States.
Okay, well, do we really have a well-functioning democracy, however? I mean, that we have a healthcare system that seems broken, that a lot of people don't have access to. We have an educational system that's broken, and that especially poor children in this country don't get a good education. We have women who are still paid less on the dollar than men.
Ken, I must jump in. I mean, these are all very controversial political issues about which are going to be debated in our political system. And of course, there are many people who don't agree that the best way of having a healthcare system is to move to a more socialized system of medicine, and that's a legitimate form of debate. That is the essence of domestic democracy. And I'm not here to claim that everything in the United States is perfect. The question is a process question of what's the best way of getting to a more perfect union, and my claim is domestic processes are likely in our structure. I'm not just singling out the United States. I'm Britain, France. I'd say the same thing if I were speaking in many European languages.
Yeah, but I think the way you pose the question, I mean, look, there are arguments as to the content of rights, which, in my view, over the centuries and the decades, is a dynamic thing, right? So, you can have a discussion. I mean, the international treaties and most international practice would claim a larger zone of rights, economic and social rights, than we have typically done in the United States, and I favor that. But that's a discussion one can have. But just to stick to the very fundamental things, we don't have that's almost on some level, a luxurious issue since we're torturing people. So there's something we don't have any doubt about the kind of, whether that's within the realm of rights at all. And I think that, to your point, it is one of the greatest tragedies of the last 7 years is that whatever moral authority the United States had to argue about other countries' human rights practices has been severely eroded. I mean, if you could catalog a long list of repressive countries who have cited United States practice by way of justifying, their own arbitrary detention, torture, whatever you may. The United States has never had totally clean hands, of course, on human rights. No country does, and we have plenty to be ashamed of in our past from what we did, what our client states in Central America did, all kinds of things. But the more recent kind of, at least we were denying it and kind of ashamed of it. Now we kind of argue that it's okay, and there's been a great cost to that. I have been hopeful under whatever administration succeeds will be restored to some extent. The last couple of days, McCain's response to the Boumediene decision has been a little disturbing to me. But I still hold out the hope that we could do better. We could hardly do worse.
Well, okay, and I want to come back to the issue of what a new administration might do, but before I do, I guess I want to pick up on something else John said, and just pose it as a question, which is whether the UN is really, the United Nations and, you know, the CERD Committee and other human rights treaty bodies are the place for addressing these kinds of social justice issues, whether it's racial justice, gender justice, or other forms of justice.
What do you? I think yes. You know, and for the CERT, I mean, there's sort of a short answer, which I'll give, and then maybe I'll try and give a more nuanced one. But I mean, you know, the United States ratified CERT, and the thing about CERT is there, you know, there's no international court that sort of tells us what to do. It's not self-executing. The only thing sort of that keeps countries' feet to the fire for CERT is this review process, and it's a very simple process, really. You know, every 4 years, I think it's every 4 years, you know, countries who ratify the treaty have to go before this UN committee. It's a committee of human rights experts. The U.S. and it forces the United States actually to write a report and to think about what have we been doing to ratify this treaty. And then there's a dialogue between the committee, and then the committee issues concluding observations. And I think it's you know, it's a valuable process because it forces the United States to think about what we're doing, and there's a process by which civil society actually is invited and encouraged to participate. It opens up another space for dialogue for the United States to hear about what its people are thinking about in terms of its implementation of the treaty, and it moves us, I think, towards thinking about how to implement it. The other thing that I think well, you know, I think some of my other remarks might be in reaction to this idea that other countries or the experts on the panel really can't comment on the United States, because I feel like I've heard that before. I don't know if that's your view.
Certainly for you to comment.
Yeah. You know, but I think the thing about that the experts on the panel, they're independent human rights experts. They're actually not representatives of their country, and although, you know, they're not Americans, they hear reviews from countries all over the world. They sit in session twice a year, and they review several different countries. So they have the expertise of looking at several different countries all over the world in different contexts, and thinking about racial justice issues. I think the other thing that I thought was interesting when I was at the CERD review, there was a gentleman who was sitting next to me who's a 60-year-old African American, and there was a discussion about structural racism. And after the review, he looked at me. He said, I'm 60 years old, and I've never felt more affirmed as an African American man than I do right now. So this idea that just because these are people who are not Americans, they don't understand what what racism is in the United States, I think is not necessarily true, or maybe it depends on who you are.
So I want to be clear here, though. I mean, there's nothing wrong if all we're talking about is international talking forums. That's absolutely fine. One welcomes that. One welcomes international criticism of the United States, and then we can consider whether that criticism is well-founded. My concern, I think the substantial concern about international human rights is the idea of having these international human rights norms and enforcing them in some sense in the United States outside of our democratic process. That's the concern, I think, that people have about international human rights. Not at all that it's some part of the international discussion. More discussion is fine in that respect. If all the UN is going to do is going to have more discussion. I mean, I'm not confident how much value it's going to have compared to, again, other things we're going to be discussing in the United States, but there's no strong objection to talk.
Well, okay, so Cindy and John raise interesting points. On the one hand, Cindy points out that CERD and other human rights treaties advance a different kind of paradigm about equality. This man that you mentioned, you met in Geneva, who said he felt affirmed. CERD not only addresses discriminatory intent, but discriminatory impact. It requires affirmative action. And if we look at the Women's Convention, it requires affirmative steps on the part of government to equalize women's rights. And of course, the economic rights, like the right to health care and education, also require affirmative steps on the part of government. So it's really a different kind of paradigm. But John, when you raised the question of enforcement, and just thinking about the United Nations role, human rights is a primary purpose of the UN and the UN Charter. And the Security Council, while the focus is really peace and security, international peace and security, we're beginning to see how the Security Council, which is the one part of the UN that has enforcement, can take enforcement measures, is reconceptualizing security to include human security. So when we look at Darfur and the delivery of food aid in conflict situations, the UN now can force its way into situations like that by sending in peacekeepers or peace enforcement personnel to use force, if necessary, to deliver food aid and to realize the rights of people in those situations. Is there a problem with that, with the UN taking enforcement action like that, whether it's in Darfur or the United States? I'm not suggesting the UN should invade the United States, but take other enforcement action.
Again, I see an asymmetry there, not only between the United States but other well-functioning democracies. There seems to be some substantial argument that we could enforce Darfur, or there was a discussion of enforcing matters in Burma, enforcing the duty to protect. I'm not saying we should do that, but I think that raises very substantially different questions, because there we do not have at all a functioning democratic system. And if that's a focus, of international human rights, to which I have much greater sympathy than bringing it back and having any direct effect in the United States. I have to mention, Catherine, that when you say the CERD requires affirmative action, the government, when it said we were going to ratify it, actually went out of its way to say it doesn't require affirmative action. So that's the kind of thing, the kind of bait and switch, I must say, that I worry a bit about in the human rights area, because that's actually in the transmission of CERD to the Senate. There was a Q&A, and does it require affirmative action? And they said emphatically not.
Well, I think Cindy might want to clarify that.
I haven't looked at the reservation. Do you mean there was a reservation?
No, there was a discussion of a Q&A about what was before the Senate. The administration was asked, not surprisingly, senators had questions. Well, does this require affirmative action? And I have it right here. They said, no, it does not.
Well, I mean, I think the treaty is pretty clear, actually, on its face that it covers, it includes temporary special measures. I think there's a question about whether there's an RUD, whether the U.S. reserved. Which
well, my understanding is that when the U.S. ratified CERD, it said what it frequently does for these treaties, which is that the scope of the rights won't go further than those covered under the U.S. Constitution, which means as interpreted by the Supreme Court. And as we saw as frequently as last year in the Seattle Schools case that we've discussed in other panels, the Supreme Court has left the door open for race being taken into consideration, say, in assignment of children in elementary school.
I just want to say a word about this bait and switch, though, because I think it's interesting in thinking about, the U.S. ratified CERD in 1994, and if you think about sort of where we've come as a country and how our law has actually gone backwards. So if you think about disparate impact, I mean, the Sandoval case means that we can't sue under, Title IX to enforce disparate, Title VI to enforce disparate impact regulation. So in fact, we probably were closer to sort of conforming to CERD when we ratified, and actually our law has gone backwards.
Well, let me ask, and then I want to open it up to the audience, just what a new administration can do. Do we need new forms of governance around this issue? We see some existing models or previous models. Wendy Patton participated in President Clinton's interagency working group on human rights treaty implementation. Do we need a human rights division of the Justice Department the way we have a civil rights division? Should congressional oversight committees that exist now play a more active role in domestic human rights oversight as well as in its foreign policy? What role should courts play? But when we think about the fact that we'll have a new president in January, what role should a new president play? around
I
these
heard
issues.
someone was doing a blueprint on human rights policy in the new administration,
That's a little
so that
commercial.
might be a good place to look. Aren't you doing that? Yeah.
Yes, the ACS working group is working on
So
a
we'll have to
blueprint on
get our
these
guidance from that. I mean, I think it would be nice to have a president who believed in the rule of law and was willing to articulate those values, and use the pulpit of the presidency to kind of teach. So I think that, as I say, I think that this isn't a partisan gathering, but both presidential candidates would be a vast improvement potentially on what we now have. I think it seems to me I haven't heard either of them address these kinds of issues directly, although I'm likely that Obama has at some point in his life. But I think the kind of there's a happily, I think, a general view in the country that and around the world that the United States has to kind of rejoin the world community, and that one of the great failings of this administration in its approach to the world has been, unilateralism and disrespect and disdain for the rest of the world. I think both presidential candidates understand that. So I think that actually kind of coming more into the community of international law would be a nice part of that. And I think so. In that sense, I think we're kind of well, primed to open this up. It's been used as a right-wing wedge issue in recent years, right? Justice Kennedy and the ones who said, and I don't think this has a lot of legs. We'll see what happens with the reaction to the Guantanamo case, but I don't, for a variety of reasons, I don't think those arguments, work as well as they did, and I think again an odd kind of side effect of the disdain for law of the past administration is the kind of opening up a broader discussion about international standards, Geneva Conventions, and so on. I mean, people have some sense that there are things that we are bound to respect. They're so I think we're a very long way from where we need to be, but I think the kind of curve is coming back up. So I think there's some possibility, and I think you might have, you have different scenarios, some more appealing than others. So.
You want to go?
Yeah. As Catherine alluded to, there was a Clinton-era executive order from 1998. It's from around the 40th anniversary of the Universal Declaration on Human Rights, 10 years ago, to create a National Security Council-led interagency working group that was tasked with doing, coordination around centrally the reporting to the treaty bodies under the, by then, 3 main international human rights treaties that have been ratified, but more broadly than that, assuring full implementation. And so I think it's a great time to be asking this question. I think there are a number of things that could be considered, from reinvigorating that body to other structures that could promote both meaningful interagency coordination around these questions, but also clear lines of responsibility and ownership within each agency about what does it mean to implement the obligations we've undertaken. I think it's also helpful that we now have a new subcommittee on the Senate Judiciary Committee that deals with human rights and the law, which came into existence last year in 2007 and is chaired by Senator Durbin, and that helps us to have some congressional oversight on some of these questions. But I think I would say, especially having been in government, that while structure is certainly important and we want to have structures that work and make sense so that these obligations can be undertaken in a way that's workable, I think what's really important is a question of leadership, and that different structures could work, but what's key is for a new president and new administration to indicate that this is a high priority. And I think it matters not only because we want to say that we take very seriously our own obligations. When we undertake them, we mean to implement them, and we mean to do that seriously. But also for some of the other reasons we've discussed today, in terms of the promotion of human rights being a central part of our foreign policy. I don't know how many of you went to the detainee panel yesterday, but Alberto Mora, the former General Counsel of the Navy, made just this point, that since World War II, the promotion of human rights has been a central tenet of U.S. foreign policy, and that has served our interest, and that we need to reclaim that and to recognize that we have long wanted to strengthen the international regime, and that should be an important, I would very much say that should be an important priority of a new administration. And part of how we do that is by saying we take it really seriously here at home. So I hope that we will consider either looking at past structures or some combination in a way that helps the full range of domestic agencies to implement these. And that also, there's a whole other question of how the federal government ought to be relating to state and local governments around this question, which is more complicated, but I think a number of things can be done to sort of facilitate that understanding and awareness so that we really are representing the full picture of everything we're doing to try to implement these obligations.
Cindy or John?
Do you want to? You want to go last? Okay.
Go either way.
No, all right, I'll go, and then you go. You can go last. I'll let you have the last word on this. I agree with Wendy. I think actually one thing I think that was really great that the Bush administration did is actually that we now are up to date on our treaty reporting. So, there was an effort by the Bush administration, and I think we should credit them with that. I think, though, we need to think about how to make the reporting and review process more robust. So I think that there really needs to be more dialogue with civil society earlier, I think, in putting these reports together. I think that there, as Wendy mentioned, and I have to say I think it's a big undertaking, but I think there really has to be greater effort to get more and better information, especially from the state and local level. We had a series of meetings actually with the State Department to ask them about what they were doing to get information at the state level, and they would say, well, we write letters to the state attorneys general, and they never write us back. And then we said, well, then what do you do? And they say, we do web searches. And it's kind of funny, but actually we went to a few meetings, and this was a response repeatedly. And I think that, and it's not to say that it's not difficult to try and get information from 50 states, but I think that there needs to be a process created that facilitates that, and there needs to be funding for that. I think that there should be, that because the treaty is not self-executing, we really need to think more about implementation and creating structures that would facilitate the reporting requirement, but also educate government officials about our treaty obligations. In some countries, there are human rights commissions that might review legislation or comment on legislation proactively. So there's stuff that can be done along those lines. There's actually a lot of state and local initiatives where actually people at the local level are taking it on themselves to actually pass human rights ordinances and human rights laws. And I think that that's actually really exciting because I think it creates sort of these laboratories to experiment and think about how we might implement human rights in a way that is consistent with what the people want on a local level. And then the last thing I think that the United States should do is we should signal an end to U.S. exceptionalism by ratifying the Women's Convention and ratifying the CRC and the Migrants Convention. But I think I will add a caveat to that I think that if we do ratify them, that we should do it in a meaningful way, and that includes not attaching reservations that really undermine the substance of the treaty, and also creating these implementation structures.
John.
Well, I have a somewhat different view of how an administration would maximize international human rights around the world. While I don't necessarily disagree with everything else that's been said, the most important thing is that we keep our nation open to both goods and people from around the world. International trade makes people wealthier around the world, and we simply can make people wealthier by letting them trade more, letting their agricultural goods more into this country. And over the time, there seems to be no doubt that a rising middle class in nations around the world, that's how things happened in the United Kingdom to begin with, even I think it's happening even in China now, some greater pressure on human rights. That's the way to have internal pressure for human rights, to have a rising middle class. And the best way we can do that is to keep our borders open to goods and services from the world and to people, because when they come here, they often send money back and make things richer, or make their compatriots wealthier, but also because giving exit rights to people around the world puts pressure on their governments, right? The Berlin Wall is an excellent example that if there's a very attractive place where people can go, that exerts a lot of pressure. They just couldn't have a freedom of exit. And I think it's unfortunate that the United States, there is talk about restricting immigration in the United States. Because it's not only rights of emigration that work, it's rights of immigration to make those exit rights a powerful leverage on nations around the world. So I think that kind of openness to goods and people is something that we can do almost unilaterally. We don't even have to agree with any other nations to do these things we can do a great deal for human rights over the long term.
Well, I think on the one hand, it's important to acknowledge, as Cindy did, where the Bush administration has done a good job, for instance, with working with state and local government to provide information on how foreign nationals on death row should have access to their consulates for advice in the aftermath of the International Court of Justice decision. And on the other hand, because it does seem that we're in a transitional moment in this country, grappling with issues around what is our responsibility and accountability under the Torture Convention along with other treaties, we may want to revisit in a new administration setting up a national human rights institution, as other countries have that have gone through transitional moments. We established a U.S. Civil Rights Commission when we went through a transitional moment in the 1960s around civil rights, and perhaps it's time for us to do the same on human rights. Let's open it up to the audience and give you all a chance. Okay, I'm going to start over here in the front. Yes.
Hi. Firstly, I'd like to... Is this on? Okay. I'd like to congratulate John for saying with a straight face that he thought it was perfectly all right for imposing the Women's Rights Convention on Afghanistan and not taking it on ourselves. I thought that was great that you were able to do that with a great straight face, with no sense of that it was how arrogant it might sound. To the substance of the argument, rights are frequently competing rights. And there are, let me give you three very short examples. Children's rights. If there's the parents and then there's the government. If the choice is imposing the government on the parents, well, parents don't do the greatest job in the world. I'm an example of that. It seems that the Texas welfare system, which competes with Florida for the worst in the world, might not have done a great job when it sent Baptist buses into the LDF, fundamentalist LDF thing, took all the kids out and brought them to Baptist houses. That's not to say that child abuse is a great thing, but it wasn't exactly proven that it was, and that monolith of Texas going in reminds me a little bit of the pressure from international organizations. Children's rights, let's go for them, and then there's some downside to going for them. And American Indian rights, another example. Tribal sovereignty frequently leads to sort of a paternalistic leadership on tribes, and maybe, for instance, women lose their rights, property rights to the extent they exist in tribes when they marry outside the tribes, but men don't, and then there's always that stuff of child abuse and women abuse in the tribes. And lastly, as an example, religious rights. And we don't have to go much past the Danish cartoons to see that the imposition of the protection of those religious rights has an enormous downside. And I think it's lousy that 33 states in America allow people to be fired and hired on the basis of their sexual orientation. But John is right. At least we don't stone people to death the way they do in other places. So the imposition of a monolithic human rights by an created by an international legislative body and imposed by some international tribunal scares the feathers out of me. And I wonder if you guys can comment on that. How do we protect what's uniquely American, which is the protection against the tyranny of the majority when giving those rights over to the majority?
Is there someone
Do you
who'd
want
like
to start?
to?
You want? I think those are really good. That's a really good question. First of all, let me say, with the CRC, and I'm not an expert on the CRC,
Children's Rights Convention.
The Children's Rights Convention, but there is language. It doesn't say that that parents have no rights or parents shouldn't be involved in in decisions relating to children. It's more nuanced than that. The other thing, I think that you're right that there's a dialogue, and sort of the thing that's exciting about the human rights treaties is the creation of the treaties is a dialogue, first of all. And the United States, I think, is frequently involved in the drafting of these treaties. So it's not like there's an international working group that doesn't include the United States. The third thing is that I think one thing that we hear when we meet with State Department about treaty ratification, they say, the reason why we haven't ratified the treaties is because we really take them seriously, and we don't want to ratify something where we're not in full compliance. And I think one thing that's interesting about the United States is that with the ratification of treaties in the past, there has been a review of the treaties, and there's been a dialogue thinking about the extent to which what's in the treaties is consistent with where we are or where we want to be. And we are allowed, countries are allowed to attach reservations to treaties. So for instance, with CERD, the United States has a reservation saying that we are not going to accept any obligation that's inconsistent with the First Amendment. And I think that is a recognition that, maybe we're in a different place and we have a different tradition. And I think that, the international community, I think, by and large, they might not like it, but they respect it and its value. And then maybe the last point, and maybe I'll let Wendy add something, is there isn't any international body that's forcing us to do stuff once we ratify treaties. Again, it's this review process. There's no international court, and the decisions even of the treaty bodies are not self-executing. So really, it's about a dialogue with this committee, and then we take it home, and then the activists really have to use what comes out of the committee, and that's sort of contested, and they have to make it acceptable and within their communities. So it's not like it's something that's being forced on us. Does that make sense? Yeah.
And actually, I just wanted to say very briefly that on the conflict of rights point that you make, which I think is an important one, it's interesting to see that, especially in the context of gender and religion, which oftentimes is the conflict that people talk about, that there are many women in many parts of the world, and the Muslim world is a really good example of this, where women are trying to use religious freedom to, interpret the Quran in a way that advances gender equality. So it's not seeing religion and gender equality as at odds with each other, but really trying to say, just as we don't want anyone to dictate top-down what human rights is, so too we don't want anyone to dictate what culture or religion is for us. So I think those are really important models to look at. And also just on your broader point about not having this kind of top-down enforcement, one of the very important things about the human rights paradigm is that it envisions that countries take the lead in domestic implementation of human rights rather than international bodies. The international bodies are only there to fill in where the states have failed to guarantee rights in the first instance at the local level. Let me go over here. Yes.
Hi. Hi. Professor Powell, is it? You mentioned how in CERD, I think it's in the concluding observations, they recommend that the U.S. actually establish a Human Rights Institute. We currently have the U.S. Civil Commission on Human Rights, which most people in the human rights and civil rights community in America do not like, especially right now. And so I wanted to get your opinion, as well as the rest of the panel. And one of the reasons why we don't like it is because there's, I'll just give you a brief example. After September 11th, Peter Carcinow went to Dearborn, Michigan, and said, if there's another September 11th attack that occurs, you can forget about all your civil rights. And he said it with a straight face, and he didn't have much qualms about saying stuff like that. So I wanted to get the panel's opinion as to what do they think about establishing a civil and human rights commission that would in part incorporate some of the recommendations from the CERD committee, as well as try to live up to its original mandate. Second question has to do with the doctrine of, or the notion of responsibility to protect, and how sovereignty is a very sensitive issue. Of course, most people would say the UN should go into places like Darfur or Burma, for example, and try to assist people who, because of the government has either been unwilling or unable to actually address the basic human needs and basic services of its people. But at the same time, there's also a little bit of skittishness, at least from very centrist Democrats in the United States. Secretary Albright in the New York Times had a piece saying that, while there was all this lip service paid to, notions like responsibility to protect during the 90s, there's been a retreat from trying to actually vigorously enforce this norm, and I think that's been a real been a real setback for us, because I think, and this is going to the point on symmetry, with Katrina, we could have used the United Nations. personally, because they could have came in, they could have assisted people. They have actually much more training, especially with peacekeeping and a lot of other exercises during the 90s and during other periods, about coming in and actually assisting people who need these basic services and basic needs that need to be met. And so I just wanted to sort of throw that out there and see if there's any type of notion of sovereignty and how we can work with the internet, with international bodies like the UN to come in and actually assist the United States when we need something like this to occur, as well as Afghanistan or Burma or Darfur in Sudan.
Okay, and why don't we actually, I'm torn because I know we have about 10 minutes left, and I'm thinking maybe we can just take one other question and kind of bank the questions, because I know you had your hand up.
My question is, why not pursue domestic federal legislation like a 2009 Federal Act, Human Rights Act, like the UK Act 68?
Great. Okay, let me turn to the panelists and see if anyone would like to take on.
Well, I'll just answer that. I mean, there were 2 or 3 questions packed in the first one, and I'm not as competent to deal with the responsibility to protect. But I think on the question of the Civil Rights Commission, yeah, I mean, I think the problem with the U.S. Civil Rights Commission, which I haven't followed closely in recent years, is that when you have a government that's determined not to make it meaningful, when the people who are, appointed to agencies that are supposed to protect rights are people who very often are hostile to them. You saw that in the Reagan administration. We've seen it to a fairly fine degree in many respects in the Bush administration. It's hard to have much confidence in these bodies. And so one forgets that there is something like the U.S. Civil Rights Commission that could actually be a meaningful body. I just read the Kerner Commission report a couple of weeks ago, which was issued 40 years ago. And, you don't have to go that far back to find, a governmental document that talks in very, honest and compelling and graphic terms about structural racism and the challenges we have in this country. History isn't that old, So it's possible to imagine, actually, in a different kind of administration, the wheel turning as it is, that you could actually have people who care about civil rights and the expansion of human rights, in positions of responsibility to do something about it. And one of the exciting things about ACS, just to put a plug in for ACS, which when I was at OSI we were one of the original funders of, is that it was meant to lay the groundwork for the time when you could imagine, not just fighting constantly the forces of reaction, but that there may be an opportunity at some point to pick up get back on the road, that we were on 40 or more years ago. And I think, it may be possible to imagine that because of the existence of ACS and what we've all been doing over the last 5 or 6 years, you've got a cadre of people who have been thinking about this and are ready to go and do it. So the Civil Rights Commission is one place, and there are many other places in the government where, with the right people and the right commitment, we could really do something good.
Maybe I'll also I want to link the 2 questions. I know you had the question about the human rights institutions that you directed toward me. And I think one thing that's interesting is the UK model, where they have passed legislation, actually creates a UK Commission on Equality and Human Rights to enforce the Human Rights Act there. And so that might be, I think that's definitely a model for us to look at to see what the successes and failures of that are. They're having a big discussion now in the UK about, is it British rights or human rights? There's a bit of a backlash now, and that's, very much caught up in the politics of the Tory party versus the Labour Party. But
if I may say, I woke up in London this morning, so I have some standing to say that the UK at the moment is not a great paradigm of human rights.
Okay, so we need to look at that and perhaps other comparative experience. My father was the general counsel of the U.S. Commission on Civil Rights in the Nixon administration. He was a black Republican, so John, you and I may have something to talk about there. He's not alive anymore, so unfortunately, I can't ask him what went wrong. But I think that clearly we need to look at new models of governance, and I think we can benefit from looking at other human rights commissions overseas. I think we need to envision ways for civil society and government to form partnerships in identifying what the standards should be with reference to international human rights standards, in establishing mechanisms of accountability, in creating transparent vehicles for civil society to be involved in the ongoing work of a human rights commission. So I think we can learn a lot from the shortcomings of the Civil Rights Commission as well as human rights commissions abroad. Let's try to take a couple more questions before. Maybe if we can have the four of you ask your questions briefly, and then we'll have the panelists conclude. So let's start right here.
I was just wondering if any of you thought. I was just wondering if any of you thought that the U.S. will ever ratify CEDAW.
Great. The question we're all asking. Yes, go ahead.
I can fit nicely with that. I'm wondering about the content of rights, and from what I've seen, it moves incredibly slowly to be expansive, and I think maybe Cindy's best place to answer. How do you, and Carol LaMarche mentioned doing a similar thing at Human Rights Watch, of how do you expand human rights to include women's rights, and particularly reproductive rights, which are not acknowledged in that way by many people, besides CEDAW.
Great. And right, okay. And I think up here, did you have a question? Sure. Okay, so let's have the panelists respond to this final round of questions.
You want to,
Gara, would you like to?
I have a lot to say about this.
Why don't you start?
Well, it's funny, the question about CEDAW, because I think that this is, I'm at the Center for Reproductive Rights, and this is something that we're really struggling with, because on the one hand, I think obviously we're in favor of U.S. ratification of CEDAW, but, there's sort of political forces that are making it difficult. And I think, and I think this goes back to the discussion we had before about how there's an international conversation about human rights treaties and human rights ratification, and there's a domestic conversation. And I think that, the strategy for ratification of human rights treaties historically has really been to sort of attach RUDs, or to say, these treaties really are sort of consistent with the rights that we have in the United States, and that it's really important for us to ratify because we want to be part of this international conversation. And so that means, for me as an activist in the United States, often I think that what that means is that the treaty gets watered down, right, that we attach RUDs to anything that would actually make a difference in our country, and we make the treaty non-self-executing. And I think that there's a certain point at which, what you lose as a domestic activist becomes too much. And the other thing that I will say is I also feel like with CEDAW, the strategy of we're going to ratify the treaty and we're going to talk about it as a foreign relations thing that's not really going to affect the United States, and sort of it won't be politically a big deal. I think that that's not going to happen because it's already politically a big deal. I think that the right really has focused on this treaty for better or for worse. And I think that if we sort of have a strategy where we're going to water down the treaty, then I think what happens is that we actually don't have any domestic activists. There's no reason for people in the United States to actually get excited about the treaty. So I think in some ways, if we try to ratify a treaty that means more, then maybe there'll be more social activism behind the treaty. But this is something I think that we're still really struggling with. How to expand human rights. This is also a great question for me now, because I'm at the Center for Reproductive Rights, and I've been there since January. And the center, it's really exciting because the center has both a domestic program where we work on reproductive rights in the United States, and an international program. And our international program has really been working on expanding recognition of reproductive rights as human rights, and within the International Human Rights Committee, human rights bodies. And I think that it's a slow process. I think the other thing, though, is that the rights might look a little bit different, right? So when we're talking about reproductive rights internationally, it's actually a different discussion. It's about the right to health. It's about, when we talk about abortion, it's actually the right to life, but it's the right to life of the mother. And it's actually the right for the mother because of unsafe abortion and the high maternal mortality rate around the world. So I think that there's an opportunity to influence this international dialogue, but it's interesting because the reasons and the justifications for the rights might look a little different, and I think that that's actually helpful for the way that we understand the rights in the United States.
Can I just want to make broad point. I mean, look, there are. I mean, this goes back to Woody's original question, but fearing that international bodies are going to kind of take away our precious rights, kind of thing. I mean, look, there are issues of content. There are issues of. It's not that there aren't clashes among rights, or there aren't very important issues at stake, and that it's never appropriate, to put a reservation on the ratification of the convention. But I just want to make the general point that, in general, the invocation of the existence of and the invocation of continental or international standards has lifted, not suppressed. Lifted. I mean, so if you look all over Europe and the countries that joined the European Union, you find them all needing to do things to improve their rights situation so that they can become part of the European Union. Now, Europe is not, maybe you might think Europe's exceptional, but in general, and it's a broad generalization, there may be exceptions to it, I think we have much, much more to gain as a planet, from countries aspiring to join the body of international law than any dumbing down that might take place. Even in this country, if you take a broad view of rights that includes, things that most of the rest of the world takes for granted, health care, housing, employment, so on, we have more to gain, in my view, than to lose. That's my broad point.
I just jump in and agree with Cynthia. I absolutely agree that if we would certainly not want to ratify the Women's Rights Treaty unless we actually agreed with the rights in it. And that's, I think it would lose if we actually looked at it. It would certainly lose because actually I just looked at the committee that's been implementing it, and it's been discussing things like comparable worth, and we should have a debate about that. But that's the reason that it seems to me international human rights has a limited usefulness in a democracy. Insofar as it has good ideas, we can debate them and put them in our democracy. Insofar as it doesn't, we shouldn't ratify that. So I'm very sympathetic not to ratifying these treaties just as symbols and not taking their content seriously. Let's by all means debate these, because I think this goes to the last comment as well. I think there's a lot of disagreement about what human rights is. I think, for instance, that having greater socialized medicine in the long run is likely to hurt a lot of people. And that's the kind of debate that democracy has to decide. And I think we're a pretty well functioning democracy and are poised to be able to make those decisions without actually a lot of help from international human rights treaties.
Well, just a quick point. I think that the question of, reservations to CEDAW should be viewed in its global context, too, because if I am not mistaken, CEDAW is the most heavily reserved treaty among human rights treaties. So it does raise this broad question of what does it mean when governments engage if they can say, except we're not going to change anything about our policy in this whole wide swath of area. So much so that it's prompted a lot of legal academic debate about is there a point at which the number and kind of reservations should disqualify the ratification of the treaty. But leaving aside that legal question, I think, as Cindy was saying, there's sort of a larger question here in the U.S.'s engagement with this is how we do it, because this treaty is so heavily reserved, will affect in some way the adherence by other governments to CEDAW, and whether it's okay to say we're committing but we're really not, or we really mean to do something and to embrace something meaningful with respect to discrimination on the basis of gender. But I wanted to sort of come back to Gara's larger and I think more hopeful point about what human rights means. And in that sense, I hope that the day will come that we will ratify CEDAW. I have a memory of at one time when I was working at the Justice Department, meeting with a group of African women lawyers who had come to visit on a kind of a tour of the U.S. and talking with different people working on the problem of violence against women. And I was reciting all of the different things we were doing at the Justice Department, creating a Violence Against Women office, this massive new grant program, a new law. And somewhere in that conversation, it came up that we hadn't ratified CEDAW. And I remember this one woman saying to me, she just stopped the whole conversation and said, "What?" She was stunned. She couldn't believe it. She thought, you have all these programs. We can't imagine having an office on violence against women in our Ministry of Justice. And yet you haven't ratified CEDAW. She couldn't compute those two things. And so I it was hard to try to explain what our debate had been about and why we weren't there, when I think so many of the principles in CEDAW are really very common principles of non-discrimination that we have long accepted as part of our, as core principles in which we all believe. So I hope for the day when it happens.
Just briefly, a CEDAW specific point and a broader one, when CEDAW has come up for ratification before, for instance, during the Clinton administration, it was very much packaged as a foreign policy idea that, Joe Biden said, we need to sit at the CEDAW table to have influence over the women and the women's rights in Afghanistan. We need to ratify this treaty. It was really seen as a way of liberating Muslim women. And I remember having a conversation with Nick Kristof, the columnist for the New York Times, saying to him, really, people shouldn't be scared about this. It's really to help women overseas. And he wrote a column saying, this really has nothing to do with the rights of women in the U.S. It's about the women who every day are dying, And I thought, oh, my goodness, what have I done? So I just don't know that that's the way to go. It didn't work in the past. I'm not clear that that's the way to, so I think we need to rethink the strategy. More generally speaking, none of the candidates for president have really spoken directly about this issue of human rights in the U.S. outside of the issue of torture. And now that Hillary Clinton is no longer in the race, I think we're really going to have to look to Senators McCain and Obama to speak about the rights of women and about the rights of all of us and about human rights and bringing human rights home. Thank you all, and thank you very much to the panelists.